Hello, this is Scott Horton. I will be the presenter for today's webinar on defending New York employment discrimination claims. We have opened the room for attendees to enter, and I will plan to try to get started right on time at the scheduled start time, but I want to make sure everyone has a chance to get in, so we will make sure that's working smoothly. So in a couple of minutes, hopefully we will be able to get started. In the meantime, if you are joining, hopefully you have access to the chat window. That's where you'll be able to ask questions. If there's any issue that you have, you can type it in there as well. I won't necessarily be able to deal with every technical issue that may arise. If you're having trouble, try logging out and logging back in and closing other apps on your device so that you will have more resources to be able to stream the webinar. You should have the cover slide for the webinar, Defending New York Employment Discrimination Claims, on your screen and access to that chat window. If you have those and you can hear me, then you should be ready to go, and we will get started shortly. I can see that it looks like everyone has been able to log in, or at least a good number of people are joining. So hopefully it's working fine for everyone. We will try to get started in a couple more minutes as soon as everyone has had a chance to get logged in. Again, just want to let you know I'm here. If you can see the cover slide, Defending New York Employment Discrimination Claims, then you are in good shape, as long as you can also hear me. And then you should have access to a chat window where you'll be able to ask questions. We'll go over all the logistics in just another moment or so when we officially kick off. I just want to allow everyone the chance to join the room before we get started. Okay, I'm going to get started here just momentarily. I just want to make sure that the audio is working on your end. So if one or two of you can just respond into chat that you can hear me, that will be great. Otherwise, we're ready to get started. Okay, perfect. Thank you. So again, my name is Scott Horton. I am a partner with law firm of Gunnar Cook. The law firm is based in New York City, but I actually practice outside of Buffalo, where I have my own office as well. So I do represent employers throughout the state of New York. One of the areas of my practice is this topic, helping employers defend against employment discrimination claims that have been filed in various government agencies. So what we are really going to be focused on here today is what to expect and how to respond to employees' agency filings. As we will discuss in more detail, these agency filings may go into court in certain situations. We're not going to be focusing specifically on the litigation process, but obviously some of the things we will discuss would be relevant to litigation as well. If you do have any questions, type them in the chat window as you have a chance. The question will mostly be answered at a question and answer at the end, but if I happen to see a question at a time where it's convenient for me to answer it, I will do that. You will have access to the slides for today's presentation. I will put a link up to those at the end. You will also receive an email, assuming you are registered for this webinar, by sometime tomorrow afternoon, that will give you access to the slides that way as well. With that being said, the only other disclaimer is if you do ask any questions, keep in mind that this is not a privileged communication, given that there are other people here. So don't ask anything that is too sensitive that it would need to be protected by attorney-client privilege, or that you wouldn't want others to know you are asking. So we are talking generally about discrimination claims filed with government agencies. So I'm going to start by giving an overview of the government agencies that are most likely to be involved if you're talking about claims being filed in the state of New York. Whether you're in New York or any other state in the United States, there is the possibility that an employee would file a charge of discrimination with the U.S. Equal Employment Opportunity Commission. For whatever it's worth, they are called charges when they're filed with the EEOC. With most other agencies we're going to talk about, they would be called complaints. Essentially the same thing. Either way, employee or former employee or applicant for employment is making an allegation that they believe that a discrimination law has been violated. Here are the federal laws that the Equal Employment Opportunity Commission oversees. There are a couple other laws that they oversee as well, but they're not specifically or generally applicable. Title VII covers race, color, religion, sex, and national origin discrimination. The ADEA protects employees 40 or over, or applicants 40 and over, in employment based on age. The ADA, the Americans with Disabilities Act, protects employees from disability discrimination and provide that employers have to provide reasonable accommodations in some situations to employees with disabilities. GINA, for a long time, was the newest of the laws that would have been listed here. It is now closing up on 20 years old, I think at least over 15 or 16 years old. The Genetic Information Non-Discrimination Act prohibits discrimination based on, well, genetic information. However, genetic information is defined much more broadly to include essentially family medical history. That being said, despite how long the law has now been around and the potential breadth of the term family medical history, the number of claims filed under GINA is still relatively small compared to the statutes listed here above it. The Equal Pay Act has been around a long time. It's a specific limited law that prohibits discrimination based on sex and compensation. So by and large, the principal intent of that law was to prevent employers from intentionally or potentially unintentionally paying women less than men. Not necessarily one direction, but it is limited to sex and it is limited to compensation, whereas Title VII prohibits sex discrimination more broadly. So sometimes both claims could be brought, but overall it's more likely that an employee is going to bring a Title VII claim than an Equal Pay Act claim. Finally, we have a new law that took effect most recently in the last year or so. It took effect last year, I think it was passed in 22, the Pregnant Workers Fairness Act, which basically adds some accommodation rights for workers who are pregnant. So while Title VII has protected women from pregnancy discrimination for some time, the Pregnant Workers Fairness Act expands on that by imposing a reasonable accommodation requirement. Okay, so those are the types of claims that can be brought throughout the United States. I didn't put slides on here on the coverage, but depending on the statute, it's typically 15 or 20 employees that an employer has to have to be subject to those federal laws. So if you are a very small employer with less than 15 employees and you happen to get an EEOC charge, you may be able to get it dismissed on that jurisdictional basis. As we'll discuss further, there'd be other venues in New York that the employee would still be able to go to for smaller employers. There is a 300-day filing deadline in New York and most other states. They talk about the 180-day deadline generally, although it's relatively rare that there's actually a 180-day deadline. The way the law is set up, if there's a state agency that also prohibits employment discrimination, they likely have an agreement with the EEOC for cross-filing in some cases. So the deadline where that is the case is, for whatever reason, extended by an additional 4 months to 300 days. So for whatever it's worth in New York, at least, there's a 300-day filing deadline with the EEOC, which, as you'll see, is a shorter period than the New York agencies are allowed to go back. Once something is filed with the EEOC, there is ultimately likely to be a dismissal one way or the other. And that dismissal is also in the form of what's generally known as a right to sue letter. So it's not the case where the EEOC itself is going to hold a proceeding like a trial or hearing to ultimately determine whether the federal employment discrimination statutes have been violated. What they can do is engage in conciliation. They offer mediation in many cases, and there are other conciliation processes to try to resolve a case. But if it's not ultimately resolved, and in most cases don't even go into conciliation, then the EEOC's options are either to dismiss, which is usually what it does, and then the employee is on their own to go file a lawsuit in state or federal court, technically, although usually they would end up in federal court because they're federal laws. Or the EEOC itself can bring a lawsuit against the employer. In other words, it would be EEOC versus whatever the name of the employer is, and not employee A versus the name of the employer. So the EEOC can actually become a party in a discrimination case, but otherwise it's more likely to just allow the employee the right to go file the case on their own. I do see a question about some of the specifics, how to prepare and how to handle different procedures. And I just want to give everybody the heads up that we are going to get into some of that, but I'm going to go through generally the agencies first and then circle back on some of the strategies and best practices and what to expect in that regard. The EEOC process, you're going to see this for various agencies, just so you can kind of see the differences and similarities in the different procedures. In the EEOC, like I said, there's a charge that would get filed by an employee. Once that is filed, it's sent off to the employer. Again, when I'm saying employee, that potentially includes applicant, current employee, or former employee. The employer receives a copy of the charge, and then they are asked to file a position statement. They may also be asked if they want to participate in mediation, and in some cases, participating in mediation might hold off the obligation to submit a position statement. But assuming that isn't the case, or if that hasn't solved the matter, then the respondent will issue a position statement. We'll discuss position statements more later on. Once that's submitted, there will be some form of investigation, which can include a request for information, which usually is the EEOC saying, give us this document, these types of documents that show this. They're not narrowly limited in what they do in investigation or how they do an investigation, but in most cases, because the EEOC is likely just going to be dismissing with the right to sue one way or the other, my experience is generally the EEOC investigations are not going to be as in-depth as some of the other agencies that we are going to talk about. But obviously, if it is a case that for whatever reason the EEOC is particularly interested in, or really believe that there is a clear case of some sort of significant discrimination, then they will dig harder. Ultimately, they will either decide to dismiss the case, as I said. And when they do dismiss the case, there are a couple of different findings they can make, like whether they think that there's a basis of discrimination, or whether they find that there's no basis for discrimination, or, among other things. For example, they could say they don't find that they have jurisdiction. Regardless, whatever the basis for that dismissal and right to sue is, the employee will still have the same right to sue. And that initial determination by the EEOC really doesn't or shouldn't carry very much weight once you get into the courts, other than to the extent it might be proven to be accurate. Conciliation, again, could include some form of mediation, but basically what it means is effort to try to settle the case. So if the EEOC thinks something is interesting enough that maybe, for example, they would consider litigation on their own initiative, they will try to resolve that with the employer first. If it doesn't get resolved, then they ultimately have to make the decision whether to file a lawsuit against the employer, which again is relatively rare, or dismiss it one way or the other and allow the employee to pursue a lawsuit as they would like. Then we turn in New York to the New York State Division of Human Rights. So the New York State Division of Human Rights oversees the New York State Human Rights Law. The New York State Human Rights Law prohibits discrimination in various arenas, including employment, as well as housing and public accommodation, for example. Obviously, we're focused on employment here today. So these are the categories that are protected by the New York Human Rights Law. They include, if not using exactly the same terms, generally everything that the federal laws include, usually to a greater extent. In other words, for example, the age discrimination protections of the human rights law are not based on an employee being 40 or older. They only have to be 18 to be protected from age discrimination. And in fact, technically, it's possible for someone to claim that they're being discriminated against for being younger than someone else, where it's only going in the other direction under the federal law. Some of the standards for sexual harassment, for example, are much lower under New York state law than they are federal law. And obviously, some of these categories just simply aren't protected by the laws that the EEOC oversees, such as familial and marital status. I mean, perhaps those would be covered as sex discrimination or something like that, but these direct categories are unique under state law versus the federal laws. All this by way of saying, if someone feels that they are discriminated against based on one of these characteristics, then they can file a complaint with the New York State Division of Human Rights. Anywhere in New York State, there are various regions that have regional offices but it's all one state organization or agency. When someone files with the New York State Division of Human Rights, they will most likely have their case automatically cross-filed with the EEOC. The Division of Human Rights will still usually handle the case in its entirety. The EEOC will just have some technical record that the case has been filed and cross-filed with it, only to make sure that eventually, if for whatever reason the state case gets kicked out, dismissed, even potentially resolved, then the employee has met their filing deadline in a timely manner under the federal statutes, and ultimately the EEOC could still issue a right to sue letter, notwithstanding whatever the New York State Division of Human Rights has done. Conversely, the same could or should happen if it's filed with the EEOC and the employee is within New York State, meaning the EEOC could cross-file with the Division of Human Rights. The important thing is that typically wherever the employee files, that agency is going to take the lead in investigating, and its procedures are going to be the ones that are operative. Just quickly on this slide, arrest and conviction record has this little asterisk by it, only to note that certainly there are circumstances where conviction record can be the basis for discrimination claims. There are also situations where conviction record can be valid grounds for not hiring someone or potentially firing someone. So I just want to note that's not completely absolute, but it is a protected characteristic, and there are specific laws and requirements to think about. The DHR distinctions in a certain sense from the EEOC process is that there's a 3-year filing deadline. So under the federal claim, something has to be filed within 300 days. As I said, in New York now, you can file with the Division of Human Rights for up to 3 years after the incident has occurred. Termination, for example, or incidents leading to harassment claims. Just a minor caveat on that. Technically, the 3-year deadline only applies to sexual harassment claims as of today, but starting in February 15th specifically, that has been extended to all types of employment discrimination claims. The statute of limitations to file in court has always been, or long been, 3 years anyway, but there was just more time to file in court than there was with the Division of Human Rights. Pointing to the next indication on this slide, employees can go directly to court on claims of violations of the New York State human rights law. They have the option, once they elect the option to go to court, then they can't go back to the Division of Human Rights in most cases. Sometimes they can file with the Division of Human Rights and then seek to withdraw their case to go into courts. But usually it's either or under state law, which again is a distinction from the federal laws where normally you have to go to agency before you can possibly go into court. And another key thing about the Division of Human Rights is it does have a full adjudicatory process. So if a complaint is filed with the Division of Human Rights, it can process it internally all the way up to a hearing and decision and potentially, order that the employer pay damages or engage in some other type of remedy. As compared to the EEOC, as I discussed, that can't do that. All it can do at the end of the day is try to resolve a matter and then either dismiss it or file a lawsuit in court. Here's the Division of Human Rights process. The complaint is filed, the respondent submits a position statement, and then the employee is given the opportunity to file a rebuttal responding to the employer's position statement. Once those initial steps are taken, there is some sort of investigation. Again, there's not a specific guideline on how that has to happen, but often these days what we're seeing is the investigator asking for additional information and documentation. Once they have that, then potentially wanting to speak to witnesses or possibly having a conference where both sides are present, usually remotely via Zoom at this point, and they will ask questions of the parties. It's all informal in the sense that it's not a trial or hearing at that stage. People are obviously expected to be telling the truth, but there's not cross-examination and nobody is making a final decision based on that. The investigation will ultimately be concluded and the Division of Human Rights makes a probable cause determination. The probable cause determination is either, yes, there's probable cause to believe that discrimination may have occurred, or no, there's not probable cause to believe that discrimination has occurred. The no probable cause results in the case being dismissed and ends the claims, subject to the employee appealing into the courts, which rarely happens, in part because increasingly no probable cause determinations are relatively rare, but it is possible for that determination to be appealed. Otherwise, if there's a probable cause determination, the case goes forward. Eventually, there's a settlement conference, and then following that, if the case still hasn't settled, a hearing will need to be settled or scheduled. There's a preliminary or pre-hearing conference that is held via telephone. Both the settlement conference and the pre-hearing conferences now are done by telephone or Zoom. So that pre-hearing conference will take place. That's when the hearing would be scheduled. In advance of that, the respondent, the employer, has to submit its formal answer to the complaint, which is a little bit different than some other procedures. In court, for example, the answer would come very early on. Here, they have the position statement early in the process, and then a formal answer, which is the admit, deny, and affirmative defenses, doesn't go in till right before there's a hearing if need be. The case would then proceed to what's called a public hearing. As of now, they're holding them via Zoom. They used to be in person in a conference room held before an administrative law judge who is employed by the New York State Division of Human Rights. Once there is a decision in the hearing by the judge, it's really a recommendation to the Commissioner of Human Rights, who issues the ultimate decision. And then if either party doesn't like that decision, it could be appealed into the courts. Just a quick note, be relevant, and we'll bring it back up later. The hearings are public in the sense right now that if they're being conducted by Zoom, there is a listing on the Division of Human Rights website that would show which hearings are coming up, and anyone who wants to log in has the right to request that login information. In rare cases, they may be able to, the judge may be able to block it from being a public hearing, but generally speaking, these are public, and occasionally reporters or other interested members of the public, along with friends or other people who know the parties involved, will log in. You have a couple questions back to the timing of a few different things here. So when I'm saying filing the complaint or charge within 300 days or 3 years, it goes back basically to the last incident of discrimination as a general matter. For example, if the whole case is wrongful termination, then it's generally the date of the termination. If it's harassment, it at least need to be based on the last incident of harassment, and then it's more complicated. But in some cases, if someone files just within the time period on a claim of harassment based on the last incident of harassment, the agency may be able to look back at earlier incidents on the theory that it's all part and parcel of the same pattern of harassment. So that gets more complicated, but certainly something has to have happened that constitutes potential harassment or discrimination within the last 300 days or 3 years, depending on the venue. There's also questions coming along about the timing of these processes. They're not very quick. They probably I know they technically have guidelines and timelines, but the reality is they're not strictly adhered to in a lot of cases. This Division of Human Rights process that I'm talking about right now, based on my recent experience, we're talking roughly on average, probably 3 years from a complaint being filed to a hearing being held. So there are certain timelines in place, but the bottom line is it takes a long time if this whole process goes through, and it all depends on how quickly the investigator gets to the case, how quickly the parties get the information back, what their workload is like. They are, on one hand, trying to expedite the processing in certain ways, I think, but on the other hand, the Division of Human Rights is increasingly finding probable cause, which creates more burden on their system, right or wrong. So again, the different time periods vary, but we're talking months between most of these steps and years for the overall process. The EEOC, again, it depends, because ultimately they're likely just to dismiss a case. So sometimes they do that relatively quickly in about 6 months. Other times, again, it can drag on depending on how in-depth the investigation is and how quickly the assigned people are able to get to it. I'm not going to spend too much more time on the New York City Commission on Human Rights, but for those of you who have employees within New York City, this is also important. Just like you could file with either the New York State Division of Human Rights or the EEOC, where there's coverage of both. In New York City, you also have the New York City Commission on Human Rights, where employees can and often do file employment discrimination claims. Again, there is also protection under the New York City human rights law for things like housing and public accommodation, but for employment purposes, these are the protected categories. Again, there's a lot of overlap with the New York State protected categories, and often New York State adopts new categories based on what New York City has first adopted. There are several examples of that on this list. For example, citizenship or immigration status is a relatively new protected category under the state law that I believe was first protected by city law. The latest category to be protected under New York City law is height and weight discrimination. This is a relatively novel protection across the U.S. I know there's been protection in Michigan for these discriminations for a number of years, but New York State wide currently does not prohibit height and weight discrimination, but since New York City now does, it is certainly possible that New York State will soon add that. Very similar to New York State, there is still a 1-year filing deadline, except for there's a 3-year filing deadline for gender-based or sexual harassment claims in New York City. If I didn't note it, New York State right now, even before that February change, has a 3-year filing deadline for sexual harassment claims specifically, as well as a result of some amendment that came out at the height of the Me Too era. Again, instead of going to the Commission on Human Rights, employers in New York City can go directly to court, or they could also go usually to the New York State Division of Human Rights, or if they want, they could go to the EEOC. lots of options. Technically, there are other civil rights commissions or similar bodies in other cities and counties and towns, etc., throughout New York State, but by and large, they don't anymore handle these cases very much, other than just pointing someone to file with the New York State Division of Human Rights or some other agency as applicable. But you will find them if you look for them in various other cities and counties, but usually they're more advisory or informational than they are adjudicatory in the way the New York State Division of Human Rights and the New York City Commission on Human Rights are. But New York City Commission on Human Rights does, in essence, have a full adjudicatory process. The only reason I put an asterisk there is, unlike the Division of Human Rights at the state level that does it all within one agency, in New York City, if the case survives long enough, it would go to hearing, but the hearing technically is not being conducted by the Commission on Human Rights. So I'll explain that in just a second. Here is the process for the New York City Commission on Human Rights. Again, there's a complaint filed, for whatever reason, differs from New York State, and that in addition to an early position statement, the respondent now has to file its formal answer, admitting, denying, etc. So that formal answer comes much later and potentially years down the road in the state procedure, but comes right up front for New York City. Then again, usually the complainant has the opportunity to submit a rebuttal based on whatever the employer has said. There's an investigation conducted, which ultimately leads to a probable cause determination. Now, based on information published by the New York City Commission on Human Rights, in the last few years, they have literally only found no probable cause about 4 times out of hundreds of cases. They, in New York City, do a lot more before they get to the complaint stage or before they get to the probable cause stage to either weed out complaints that don't have much merit or to settle them in some way between the parties. So the probable cause determination is pretty much a formality at this point in New York City. If the case is getting past investigation, then it's likely going to get probable cause. There then can be further efforts to mediate or conciliate, as there can be throughout the process, to settle the case. Ultimately, if there's no resolution and there's been a probable cause determination, there would be a trial, and this gets referred over to something called the Office of Administrative Trials and Hearings, with the apparently clever acronym OATH. So again, there is a full adjudicatory process within the New York City governmental regime, but technically multiple agencies and offices become involved. Regardless, ultimately there's a final decision, and if either party isn't happy with it, there can be appeals, potentially even into the courts. Just as a big picture, FYI, most of the other stuff we're talking about, the similarities and procedures, and then some of the best practices and strategies and stuff, we're going to spend most of the rest of the presentation on, would also be more or less applicable to various other agencies that could possibly handle complaints of discrimination in limited circumstances. At the federal level, you'd have the U.S. Department of Labor, which doesn't directly enforce many employment discrimination laws per se, but does oversee laws that would include anti-retaliation provisions and the like. Also oversees the FMLA, which has certain protections that the U.S. Department of Labor might get involved with. The National Labor Relations Board has the right to hear cases involving discrimination, in essence, based on union activity, for example. Occupational Safety and Health Administration, as I've learned over the years on occasion, actually has some authority over a pretty wide range of laws. And again, there are anti-retaliation and whistleblower types of protections that could result in agency investigations and proceedings with OSHA. In New York, you'd have the New York Department of Labor, which generally is not going to be too involved in any forms of discrimination, but could potentially at least receive those calls, and there would be some retaliation types of cases that would be within their jurisdiction as well. For example, an employee who has complained that they weren't paid properly and then suffered an adverse consequence might have a complaint to be made with the Department of Labor. And then, as I mentioned, there are local human rights commissions. I have actually had cases that were investigated to a decision by local human rights commissions, but that's been a while in the past. And other than New York City, you're unlikely to run into these as far as I know. And if an employee does go to these local human rights commissions, it's more likely that they will refer them elsewhere, probably the New York State Division of Human Rights. Okay, as I said, we're going to spend the most part of the rest of our hour that's allotted talking about strategies and best practices and the nuts and bolts of how to get through these processes. But first, I just wanted to throw some of the data at you to see kind of what this looks like at the federal, state, and even New York City level, to the extent there are some data available. Just to start big picture, nationwide, these are EEOC charges. So it is a little ambiguous on some of this data, whether it only is charges that are filed directly to the EEOC or also include charges that are filed with a state agency like the New York State Division of Human Rights and cross-filed with the EEOC. But regardless, without getting bogged down too much on exactly what this pool of complaints represents, you can see that there is somewhat of a general trend and a reduction in EEOC charges over the last decade or so. I started back in 2010, mostly just because it was almost right at 100,000 charges annually at that point. So it's now down. In 2021, it reached a low point of about 60,000 cases. That had something probably to do with COVID. Exactly what the impact of COVID was cuts in different directions. On one hand, there were less filings overall in a lot of government agencies involving workplace claims during COVID, probably in part just because it was logistically harder to file the claims, and maybe hopefully more so because there were fewer workplace interactions during COVID, so less things to complain about. On the other hand, COVID did prompt some novel EEOC and other discrimination charges itself, such as with the vaccine requirements that went into place. There were a number of religious discrimination charges. If you look on this chart between 2021 and 2022, you see a gap of over 10,000 cases. If we look at just the religion discrimination charges filed in 2022, you'll see that it basically accounts for that entire increase from one year to the next. And the EEOC has noted specifically in its data reporting that there was this huge increase that likely accounts for the COVID impact versus some other general increase in religion discrimination charges, which you can otherwise see were basically steady, if not declining, before COVID. We also have data on what the EEOC charges specifically in New York were. This generally appears to represent charges that were filed directly with the EEOC within New York workplaces rather than the cases that were filed with the New York State Division of Human Rights and cross-filed. But I wouldn't rest 100% confident in that distinction, at least for all of these years. Anyway, it is what it is. These are EEOC charges in New York. Again, you see the downward trend, especially with the initial impact of COVID. And you see an increase in 2022. Just before I move on, that increase in 2022, again, pretty much exactly matches the increase in religious discrimination charges. And again, is likely based on the COVID vaccine cases. I'm just going to quickly run through some of the other categories just for your reference. And again, you'll have these materials. So if you want to look back at it, it might be interesting to you or not. The race discrimination charges have gone down generally over time. National origin charges, for example, have gone down about the same as race discrimination charges. Sex discrimination charges overall also declining. Sexual harassment charges overall have also been declining. With respect to sexual harassment in particular, you'll see the uptick here in 2018, 19, and arguably a little bit into 2020 before there was the COVID impact on half of the year. That was the height of the Me Too movement, which likely contributed to or was otherwise related to the increase in sexual harassment charges being filed. I put on this chart as well the New York specific charges. This breakdown is available. It's maybe a little hard to see here, but basically the bottom line is the New York State pattern is the same as the EEOC overall pattern. Age discrimination charges, you can see, have dropped off pretty considerably by about half over the last decade or so. By contrast, though, disability discrimination charges are pretty much level. Just a slight, undulation here, but by and large, they're the same place today as they were back in 2010. Retaliation charges, similarly, are about the same level as they were a decade or so ago. The interesting thing to keep in mind about both of the disability discrimination charge levels and the retaliation charge levels is that those levels are staying consistent while the total number of cases is going down quite a bit. So the same would be relatively true for disability discrimination cases as retaliation cases, but as far as a relative matter, but you can see that now on this chart, EEOC retaliation charges account for basically half of all EEOC charges. Now, I should note that these numbers overlap in the sense that you're counted here no matter how many different cases claims are made in the same case. So the same employee could claim age discrimination, sex discrimination, and retaliation. It would count on each of the charts, except, of course, it's still only one total EEOC charge. Anyway, the bottom line is usually about half the time anyway, there is some form of retaliation charge as well as some other kind of discrimination claim. So, for example, in a sexual harassment situation, the employee is most likely not just going to complain that they were sexually harassed, but also that they did something such as filing an internal complaint for which they were then subject to further adverse treatment and therefore add a retaliation claim to their case. That really by way of showing that once there is some sort of knowledge by an employer that something might be going on, or at least the employee believes there's something going on, you want to be particularly careful to do something about it to hopefully prevent a retaliation claim, although that's not possible in all cases. Couple more of these slides before we get into the more strategy and practice type aspects of this. I just want to go back to the point I made before. The EOC can file a lawsuit, but they rarely do, in the sense that we're talking a small number of hundreds of lawsuits filed every year out of the tens of thousands of complaints filed with the EEOC. So again, you can just compare, never mind the variation in the lawsuits filed from year to year. I mean, there's a bunch of different factors that would affect that. But overall, you can see that only one or two EEOC charges out of 1,000 result in the EEOC filing a lawsuit. The others either get settled in some way or dismissed, with the employee being able to file a lawsuit themselves if they want. Have a little bit of New York State data. It's a little bit harder to pull here, but for whatever it's worth, just note that the fiscal years are different here, so it's not the same time period from New York State and New York City, but just so you have an idea of the magnitude of number of cases filed with these agencies. Again, the state claims are a fraction of what the EEOC sees, obviously, and the New York City claims are a fraction of what the state claims, but in each case is a relatively healthy fraction, because New York State is one of the more populous states, and New York City obviously accounts for a good chunk of the people and employees in New York State. Okay, now that we've gotten through that, I think you have a good background on what's going on. I want to talk about some, again, the strategies and how to handle these complaints once they come. Not necessarily the first step. I mean, you might be doing other things. You might be talking settlement or whatever. But more or less, the first procedural step, once one of these complaints gets filed and sent to the employer, is to prepare a position statement. Not one size fits all in this scenario. There are reasons in some cases to provide a whole lot of information, and potentially in other cases to try to limit your response as much as possible. It's going to depend potentially on the agency, keeping in mind, for example, that the EEOC is most likely just going to dismiss the case eventually, and the Division of Human Rights would hold its own hearing, for example. The vigor of the investigations may depend based on which agency it is, and potentially, what the nature of the allegations are. You as an employer are not required to have an attorney to deal with any of these agencies. You probably would become required to have an attorney if you ended up in court. That being said, hardly any employers that do anything other than quickly settle are going to try to handle these proceedings without an attorney. So hopefully you're working with an attorney who's done a lot of these cases, so they can get a good sense on how to provide this response. Normally, if you have an attorney working with you, the attorney will submit the position statement and sign off on it themselves versus having it come from an HR person. Different companies are set up different ways. Some people do this stuff in-house with people who aren't attorneys. But again, normally my preference, and I think most practitioners, for legitimate reasons other than just trying to generate legal fees, would suggest that whatever you want to do internally, prepare something, and then whoever, whether it's an in-house attorney or an outside attorney who's going to advise you in the case, they would be the one to repackage and submit whatever the position statement is going to be. Often these position statements are going to include some exhibits, documents that show, what actually happened. And again, how much documentation to include at that stage is also an important consideration, but it's not one size fits all. You have to really understand what's going on in the case. One relevant factor can be, does the employee have an attorney? The employee doesn't have to have an attorney to file with any of these government entities. In a proceeding with the Division of Human Rights, for example, the Division of Human Rights will have attorneys who take the case to a hearing if it goes that far. They don't technically represent the employee, but they essentially represent the employee. They present the case for them, and provide them guidance, and get documentation from them and marshal it into evidence and stuff like that throughout the case. But employees can also go through these agencies with their own privately retained attorney, which can tell you something about the motivations and how it's likely to end up. For example, an employee filing with the EEOC who has an attorney is more likely than not filing with the EEOC for the purpose of getting the right to sue letter so that they can then get into court. Whereas an attorney who's representing an employee in the New York State Division of Human Rights is probably intent on having the hearing before the New York State Division of Human Rights. So again, these are things that are good to know, and may dictate how much information or the scope of how you address your position statement in the first instance. One general strategy point is to try to tell your story and not just deny the employee's allegations. So, there is a tendency to get one of these and just say, well, no, that's not true, and that's not true. If you are at the point where you have to file an answer, then you have to do that. I mean, that's what an answer procedurally is. You're specifically taking their allegations and saying, yes, that happened. No, it didn't happen. But in a position statement, you're really trying to use a narrative to explain what you think happened and why you don't think it is discrimination. So here's a general approach to a position statement. This is not the only approach to a position statement, of course, but it is, an overall what we normally see, what lawyers are normally putting together, and what the agencies normally expect, or at least are used to seeing. So typically it would be set up as a letter that has a basic introduction. My name is so-and-so. I'm responding on behalf of the company to this charge, what have you. Then go into an overview of the company. So keeping in mind that, unless you are a huge household name, your company is probably not something that the investigator is familiar with. So you want to use this opportunity to tell them who you are, where you're located, how big or small you are. Again, obviously that could have some relevance, or if nothing else, just helps orient the investigator rather than just thinking, potentially having the wrong impression about what your company does for whatever reason, or just leaving them completely in the dark about what's actually in the background. Like, is this a factory setting? Is this an office setting? How many people actually work here? What's the structure? Who reports to who? This doesn't necessarily have to be a particularly long section. It just depends on how complicated the situation is and what the relevant aspects of your operation might be. But you want to orient the investigator somewhat. Often it's nice to go ahead and throw in information about your discrimination prevention efforts. So if you hopefully have non-discrimination policies in New York, you have to have a sexual harassment prevention policy. If you're doing your annual training, if you do other training, if you've specifically given training to employees involved in the allegations or something, you should explain that in most cases, even providing copies of the policies, etc. Obviously, if you don't have those policies, especially if you don't have the sexual harassment policy that you're required to have, you're going to be less likely to want to address that. And again, there's no formal obligation that you address anything specifically in the position statement. Then normally you want to give some overview of the employee's employment. Again, tendency might be to say, all right, well, we got a 35-year employee who's complaining they were fired over this one incident and that's discriminatory. So let's just jump right to that one incident. Sometimes that's fine, but other times, there's reason to at least start with saying this employee started working for us in 1990 and this practice was promoted 3 times to these other positions, etc. Got some discipline here, was laid off for a while, but because of XYZ circumstance was brought back, filed this complaint 20 years ago. We addressed, again, in most cases, you won't go into all that detail in all those respects. I'm just pointing out things that could potentially be relevant. If, for example, you just say, well, yeah, she started working here 35 years ago, and then she did this, and we fired her, and now she's claiming it's age discrimination. The fact that you've essentially yada, yada, 35 years of employment might sort of support the employee's statement that, well, I've been a model employee for all this time, and now suddenly I do one thing that's slightly wrong, and they're just looking for an excuse to get rid of me. That can cut both ways, but those are the types of things you're trying to persuade the investigator are not discriminatory. Then, whether in that section or in a separate section or, combination approach or whatever, you do need to respond to the allegations. That's not to say you have to specifically say employee said X. X is not true and Y is the actual truth. Employee says this and that's true, but you don't have to necessarily go word for word. Some of these complaints are pages and pages of handwritten allegations and recitations of facts that may not have much to do with anything, whatever. You don't necessarily have to address every single thing that the employee says in their complaint in the position statement. You just need to address the things that are going to be most likely to result in some finding by the investigator that there might be discrimination here. Again, especially if you're trying to get the case dismissed for other strategy purposes, you may intentionally ignore material allegations. But normally you want to try to refute all the material allegations, but you don't necessarily have to address every fact referenced in the complaint. At this stage, you would still have the opportunity to refute them later. And then you want some sort of conclusion, which ultimately basically says we didn't discriminate and you should dismiss the case. So that's the first big part of how you deal with these cases. The next big part of how you deal with these cases, I know we're running up on our time, but I'll spend a couple more minutes on this and then answer any questions and give you the slides. It is settlement. And basically, you can settle these cases at any time. Certainly, you can settle discrimination claims before they're even filed with agencies. Obviously, sometimes attorneys get involved and threaten to file claims, whether it be with an agency or in court, and those can result in settlements. But once something gets filed, there are cases where it's worth trying to get it settled immediately for whatever reasons. We'll talk about some of the factors on the next slide. There are formal procedures that are in place in most of these agencies to try to encourage settlement. Obviously, they'd rather not have to process cases longer than necessary. So, all the EEOC, New York State Division of Human Rights, and New York City Commission on Human Rights have specific processes that they often make available and sometimes are mandatory to try to resolve the case, be it mediation or some sort of settlement call with a judge or whatever. But those are not the only opportunities to settle. That's the main thing. That being said, the further you go through these proceedings, there can be more obstacles to settling. With Division of Human Rights, for example, once they file probable cause, they now won't allow private settlements without approval of settlement through the agency by the commissioner on human rights, and they will have a lot of limitations on what can be in your settlement agreement. Whereas if you do it before there's a probable cause determination, there's more flexibility, especially if the employee has their own attorney. They could reach whatever settlement they want with you and then withdraw the case without as much oversight from the agency itself. So that can be a factor in some cases. Obviously, if you do settle, this should be documented in a proper agreement that vetted by an attorney. The scenario where somebody files a complaint and then you call up the employee and say, I'll give you your job back if you withdraw the complaint, can be valid. I mean, that's not necessarily inappropriate. And sometimes it might work, but that would be the outlier situation, or you wouldn't normally want to just call up the employee and say, how about a $30 or $100 or $1,000 or whatever it is, and you just withdraw the case. Normally there would be more in writing, including a release of any claims, so that the employee doesn't take the money, come back to work, and then refile another complaint the next day or something, which in some cases they would be able to do if they were subsequently discriminated against. But again, these are legal niceties that you should be factoring into any settlement. Limitations on confidentiality and other protective terms refer to an increasing number of legal changes that makes it hard for employers to get a confidentiality provision in these types of settlements. Obviously, you don't want your employees to be talking about what they perceive to be harassment or discrimination, or your former employees talking about things like that. And there are ways you can limit what people can say, but especially if you are trying to contractually prohibit them from discussing the facts and allegations of their concerns, even after a settlement, there are some very particular rules that have to be followed. So again, make sure you work with an attorney in almost all cases if you're doing those types of things to get it right. Settlement factors. I don't want to take up too much more time. If you have any questions, and you can go ahead and start typing those in, we'll get to them in just a minute. The types of things you're going to be thinking about in settlement are what the potential damages and remedies are. For the most part, overall, the potential damages in these cases are not as high as people believe they're going to be. So usually that means the employee or person filing the complaint, they hear news reports of hundreds of thousands and millions of dollars in discrimination and harassment cases, and they think they're going to get that too. For the most part, the reality is much lower than that. But, it is still material amounts of money, depending on your organization, plus the legal fees and stuff that would be involved in potentially processing these cases out for 3 or more years. Obviously, the merits of whatever the allegations are going to be a factor. There are also evidentiary issues, and keeping in mind, because a complaint filed with the Division of Human Rights today might not be actually on the hearing calendar until, say, 2027. Will you lose witnesses by then? You shouldn't be losing documents because you should be preserving those. But, who's going to be around to still tell what happened? And even if they are still around, how well are they going to remember what happened multiple years ago? Timing issues. Again, this could mean a lot of different things. It could mean, where are we in the process? One of the key timing issues is, okay, if we settle now, that means writing a check today. If we don't settle now, it could mean possibly writing a check in 3 years, along with some legal fees along the way. In some cases, companies don't have the money to settle something right away, or need to pay out their settlement over time, or just say, if they want that much, then I'd rather just take it to the hearing and maybe they'll get the money in a couple of years. Publicity can be an issue. As I said, some of these are public hearings, or can lead to public hearings. Not everybody's going to want that to happen. Obviously, nobody probably wants it to happen, but you have different risk tolerances in that regard. These complaints with the agencies do not generally become public record as soon as they're filed. they are potentially available after the case has been resolved. But just by contrast, if somebody files something in court, then it's pretty much immediately available electronically these days on, court databases. So that's another possible consideration. The employee's specific situation. I mean, that's going to affect settlement. Somebody who's already rich but has felt they need to file this claim is probably going to be less motivated to settle for some monetary amount. They may be after another end. Somebody, on the other hand, who, has lost their job and now really doesn't have any money, might be more motivated by some money now versus a potentially bigger amount in multiple years down the road. And finally, attorney's fees. Again, if the employee has their own private attorney, that attorney, if they're successful in these cases, is going to be able to recover attorney's fees under the applicable statute. And another practicality is they're going to get some portion of any settlement. So depending on the dollar amounts involved in the settlement and how much work they've done, it could affect the individual employee or claimant's willingness to settle, because if the dollar amounts being discussed are just going to end up all going to the attorney anyway, then the employee might not have much motivation. I think this is the last point. I'm going to go through this relatively quickly and then answer questions. Again, some agency proceedings will end up in court. So assume from the beginning that's a possibility, or unless you just flat out decide we're going to settle this at all costs. Once you get the complaint or charge, you should at least assume that triggers a litigation hold obligation, meaning you have to preserve any and all records and documents that might be relevant to the claims, even if they're electronic and would otherwise be overwritten in time. You have to put holds and backup documents in native forms, and including metadata and that sort of stuff, to be fully compliant. And if you don't, that could hurt you in litigation later. Of course, you want to balance your initial defense versus your long-term outcome. That's what I said. Don't automatically give the EEOC every document you have. Just say, here, you take it and figure it out, because that's ultimately going to mean that the employee is going to get it. And especially if there's stuff in there that could be harmful if used by the right person, they might take it to an attorney, and then the attorney might get more interested in taking their case than they otherwise would. Again, that's not to say don't ever give everything you have to any of these agencies, just by way of saying there is something to be considered in that respect. Ultimately, again, you should be working with your attorneys in almost all of these cases to some extent, as you discuss with them based on the circumstances. My suggestion is provide your attorney with as much relevant documentation and information as possible up front, meaning both existing records and talking to the right people who have the information. Again, among other reasons, in addition to like determining strategy and how to proceed initially, but your attorney can also help then make sure that information is preserved as well as possible and available for whenever you need it, which again could be years down the road. So now I am going to get into the questions. Before I do that, I will throw up the link to the slides. Thank you for those of you who have stuck with us through this point. If you need to leave, then obviously I understand that. Again, you will also get an email probably mid-afternoon tomorrow with both a link to these slides and to the recording of this webinar in case there's anything you want to watch back or share it with any of your colleagues. If you haven't already typed in questions and you're going to, please do. I will wait around as long as possible to make sure there aren't any new questions to come in. Just keeping in mind, if you do ask a question, don't disclose any particularly confidential information. The first question that I see is, are you able to talk about EEOC fact-finding conferences, how they work, how to prepare, etc.? Sure. And I don't want to get specific on EEOC fact-finding conferences versus Division of Human Rights investigatory conferences. I mean, the bottom line is ultimately they work how the investigator wants them to work. there are not very strict rules on how they have to proceed and what has to happen. But generally, there's an investigator assigned by whatever the agency there is, and they want to have a conference to, get more information, and they don't want to just ask the parties to submit that information on their own. Typically, these conferences would be held with both sides at the table. Today, at the table can well mean electronically via Zoom or whatever, but both sides are there to hear what the other side has to say, which both potentially expedite settlement type discussions and also makes it easier to get to the bottom of questions that the investigator has. The investigator don't always ask what you think are the right questions. If you are a lawyer or somebody else representing your client in sort of a legal type capacity, in other words, you're not like the fact witness involved, you're going to find that you don't necessarily have a whole lot of leeway to like tell the investigator not to ask that question or to ask your own questions, especially of the other party. But, there is some room for the attorneys or whoever to say, well, maybe you should also ask about this, or isn't it right that and try to encourage, your fact people, witnesses to explain something. But again, it ultimately really comes down to what the investigator wants. They don't always ask the questions you'd like them to. Typically, after you have one of these conferences, you would be given the opportunity to submit anything that you want in addition to anything that the investigator has specifically requested. That being said, how to prepare. I mean, I personally would generally prepare about the same as I would for a deposition or a trial, but maybe not to quite the exhaustive extent. But, if I'm representing a company and two of their employees have to be present at this fact-finding conference to tell the investigator what happened, then I would go through with them what they think happened, ask them the questions that I think are going to get asked, and, tell them, anything they need to know, or make sure they review the right record beforehand. And obviously all that is a case-by-case type of analysis. But typically, again, you're not calling witnesses and cross-examining witnesses. You're just sitting there seeing what the investigator does and trying to keep them in line. Question on pay transparency. I'm going to get back to that. I'm not sure that is directly related to what we're generally talking about, but I'll try to answer it after the others. How long? There's a question on how long the investigation takes. Again, I mean, I'm not entirely exaggerating when I say I've had cases where the investigation has never been completed. There are cases where they literally have been open for decades. By and large, the investigation itself is usually completed in like 6 months to a year. I'm sure there are targets that they're supposed to be completed in timeframes along those lines. And usually the investigation itself is, and then you get the probable cause or the dismissal. But the EEOC sometimes takes longer, and the Division of Human Rights, it really depends on how deep they want to go and how available people are and how responsive people are. Yeah, there's a question about the HRCI activity ID. So yeah, this is pre-approved for an hour of HRCI credit. The approval will go out in the email tomorrow. If for some reason you don't get it, then please let me know. But I can't put it in this video generally because the approval will only go out to people who are confirmed to have been here for the whole presentation. Let me go back to the other questions I had. I'm trying to. Oh, I see. Sure. I-9 requirements contradict discrimination of immigration status. How do you comply with either one under the circumstances? They're not intended to contradict. So the I-9 requires documentation proving the right to work in the U.S. That can apply equally to people who are U.S. citizens or not U.S. citizens and of various immigration statuses. So the discrimination protections under the human rights laws in New York are for discrimination that would otherwise let me rephrase that. It doesn't excuse the fact that somebody is not allowed to work if they're not able to provide the right I-9 documentation. So, for example, if someone comes to work for you and can't provide the documentation that they're entitled to work in the country, then the employer would have the right to say, I'm sorry, you can't work for me. In fact, they would be legally entitled to say that. That wouldn't in itself constitute citizenship or immigration status discrimination. What would is if the company said, we'll only employ people who are U.S. citizens, or we'll only employ people with certain immigration statuses where there are other immigration statuses that would also equally give that person the right to work in the U.S. Or hypothetically, if someone for whatever reason wasn't actually lawfully entitled to work in the U.S., but you were nonetheless employing them, and then they were discriminated against based on their citizenship or something like that, there might be the possibility that they could make a harassment complaint. But again, at some point, if you found out this person was no longer legally entitled to work in the U.S., then you could terminate them and would need to. The other question, I see. The pay transparency. So New York City and New York State now both have separate pay transparency requirements that are not identical, but they do require generally in job postings that you list ranges. So the question here is about equal pay, the interaction between the equal pay protections and the pay transparency requirements. I'll just start by saying there's still a lot of unanswered questions about the pay transparency requirements, how big of a range it can be and how much you could deviate from it. I mean, I think generally the guidance is you are supposed to make your best guess or, best good faith range based on what you know at the time you post the job. If you later determine that no one is willing to work within that range and you have to pay more, then that doesn't mean you violated the pay transparency rules in the first instance. Or if you only can find somebody who's not as qualified as you were hoping, you could potentially pay them less. The equal pay protections and the other discrimination protections would just say whatever decision you make, whether it's consistent with your posted range or not, can't be based on sex under the equal pay law, of the federal equal pay law, under the state equal pay law, can't be based on any protected characteristic. And then under the other general discrimination provisions, it can't be based on any of those characteristics as well. Those cases can get really complicated, to be sure, independent of the pay transparency requirements. If one employee is doing allegedly something the same or similar to another employee, they're not making the same amount of money. There are numerous factors that would get debated in litigation as to whether that validly justified the distinction or if the distinction was merely a pretext for discrimination, whether intentional or not. Really good questions. I hope overall this information has been helpful to you, at least generally. I hope it's not helpful to you in the sense that I hope you don't in the near future have to respond to or deal with any of these discrimination cases, but if you do, hopefully this gives you a better idea, and you can refer back to these slides or materials to get a better idea of, okay, well, this is coming from the EEOC, so what might that mean? This is coming from the New York City Commission on Human Rights, so what might that otherwise mean? I mentioned the New York City Commission is basically not finding no probable cause. The New York State Division of Human Rights, they have some data that suggests maybe something like a quarter of their cases are still getting no probable cause determinations. Based on my personal anecdotal experience, I'd say those are like cases that are just so far away from meeting the standards that they can be dismissed. Like don't even reference a protected category or clearly just are too old or whatever, and receive no probable cause on those bases because of the lower standard for harassment cases in New York. You see an increasing number of these cases that at least include a harassment element that the investigators are seemingly reluctant to dismiss. So it is harder and harder to get a no probable cause dismissal at the state or New York City level. Meanwhile, as discussed, the EEOC is still most likely just going to dismiss the case one way or the other. I don't see any more questions that I haven't already addressed. If you did type a question, I haven't addressed it, let me know. If you have any other questions, let me know. Otherwise, I thank you all for your time. I'll just wait a few more seconds to see if anything else gets typed in. Oh, I'm sorry. I did see a further question on pay transparency. I hire someone at a higher rate is a follow-up. I hire someone at a higher rate with more credentials while an already employed employee gets less pay for the same job. Am I discriminating versus equal pay? I mean, the bottom line is I can't really answer that question. The answer I gave before, to the extent that it says there's a lot of factors, is really the best answer at this point. And I mean, none of it is per se discrimination, but the question is, could someone make the claim? Yeah, they could make the claim. Can you defend the claim by saying that this person has better credentials? Yes. Could you defend the claim by saying, well, I just hired this person, so I need to pay them more? Yes. Again, any claim would have to be based on a protected characteristic. So, I mean, theoretically, if you have two people who are identical in all respects, age, race, sex, and those types of things, then it would be harder for somebody to make a claim. If you hire somebody who's a different age, a different race, and a different sex, and pay them more than someone else who is already doing the same job, then, you know, you're going to have to somehow prove that it's not based on those protected characteristics. And there's just not going to be a clear-cut answer. And there's potentially innumerable laws that would be involved, state and federal equal pay acts and or state and federal employment discrimination laws generally. And technically the answers could be same or could be different under various laws. The New York State Equal Pay Act is broader now than the federal Equal Pay Act. So that's really the best I could say as a general matter on that topic. Good question. Very interesting area that is going to probably be increasingly litigated. Okay, well, I don't see any more questions at this point. Thanks for all of you who hung on this long. Hopefully, again, it was all helpful. If you do have any follow-up questions, my contact information is on the screen. And look forward to speaking with you next time. Probably have another webinar next month, so be on the lookout for the information about that.